Final case set for argument this morning is Slezak versus Slezak. It is case number 29102. Both sides are represented by counsel. So each side will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Again, I'll direct you to the television and on the wall. It's a good way to keep track of your time. The court has read the briefs in this matter and are ready to proceed if you are.
Thank you, Your Honor. May it please the court, I'm Robert Kehoe, counsel. It's my privilege to appear before you this morning on behalf of the appellant, Arnold Slezak. Mr. Slezak is here with us this morning, and my associate, Warren Rico, is also here with us. This case involves a closely held corporation or family business that makes equipment for the tire industry. Raymond Slezak conveyed to his 3 children in equal 1/3 shares in the entire ownership of the corporation. The 3 siblings, Fred, Cynthia, and Arnold, signed a closed corporation agreement that is referred to in the pleadings, and I'll refer to today as the CCA. The CCA sets forth the manner in which the corporation and the shareholders will be governed. After Raymond Slezak passed, the business was being run by the children. Arnold worked in the business, Fred and Cynthia did not. All were officers of the corporation. There was a dispute over employment issues and compensation that resulted in the separation from Arnold as an employee and removal by his siblings as an officer. Under the CCA, there was a dispute resolution mechanism that called for AAA arbitration. The parties utilized that process for the employment issues only. One of the remedies under the CCA in the event of a separation of employment was a sale back to the corporation of the shares. In this case, they were owned by Arnold. There are significant factual issues that were developed in the discovery phase of this case. But when I say significant, the valuation of the company could have been understated by as much as $20 million. But this appeal is not about those factual issues. This appeal is primarily procedural. And the central issue for the court's determination is whether the valuation process that was undertaken post-arbitration is subject to any type of review. What was arbitrated by Peggy Foley-Jones, who was selected by the parties as the arbitrator, were the employment issues only. The arbitration award that appellees moved to confirm was limited to the employment issues only. It is true that an appellant does not dispute that part of that order was to use the valuation mechanism in the CCA to arrive at a value and have Arnold sell the shares back to either the corporation or his siblings. The arbitration award did not deal with that post-valuation process, and the appellees expressly understood that. And if the court need look no further than the record in this case to see that a complaint was filed to A, confirm the arbitration award, B, count 1, declaratory relief. That declaratory relief was an assertion by appellees that there was a case in controversy over the valuation process, the value ascribed to the shares, and the method of payment. The second count of that complaint involved cashing checks and the method of payment for the shares that were being repurchased. So it's important for the court to appreciate the distinction between confirming an arbitration award under RC 2711 and invoking the trial court's jurisdiction on a complaint to resolve a case or controversy over the valuation process, share price, and payment, and seeking an order to compel Mr. Slezak, my client, to cash checks under a method of payment set forth in the CCA. So right at the outset, we have to look at the parties. Who was a party to the arbitration? Fred and Cynthia, as a majority, brought a claim against Arnold as a minority shareholder. RJS, the corporation, was not a party to the arbitration. RJS was a party to the complaint. One of the errors of the trial court was conflating the arbitration confirmation process under 2711 and the independent claims that were asserted in the complaint, and issuing an order that said this outcome will apply to Fred, Cynthia, Arnold, and RJS, which was never a party to the arbitration. We have asserted 4 assignments of error, and 3 of them relate to the valuation process, and whether under 2711 you can confirm issues that were never arbitrated. So the question for the court is there any review process of the valuation and share price determination, or can that be somehow folded into an arbitration that took place, clearly understanding that those events had not yet occurred? So the employment issues had occurred, the arbitration takes place in May of, and there's an award in May of 2016. And there seems to be a suggestion by the trial court that the appropriate procedure was for Arnold to file a motion to vacate within 90 days. The flaw in that reasoning is that the the appraisal process had not even been completed until November of 16. So it would not have been possible to move to vacate within 90 days. That logic also fails to appreciate that as a matter of law, you cannot confirm matters that were never decided. So clearly, those issues that had the appraisal process, price determination, which had never occurred, could have never been part of the arbitration process. Therefore, it could not be part of the confirmation process. After filing a complaint for declaratory relief on that very issue, and recognizing that RJS and the injunction were never part of the arbitration, the appellees decided to, in a pleading, not formally as a matter of record, but in a pleading, say we are going to jettison that injunctive relief claim. And towards the end of the discovery process, after it had been argued on summary judgment that the inquiry was a 2-step process, determined that perhaps the correct way to approach this problem was to stay the proceedings in the trial court and ask the court to send it back to an arbitrator to determine the appraisal issues, the appraisal issues and the share price issues. So the magistrate did not hold an evidentiary hearing. One of the issues for this court's determination is whether or not in the 9th District, on a motion to confirm, an evidentiary hearing must be held. Every district other than the 9th has held that 271109 requires an evidentiary hearing. The language in the statute states hearing. The case law is very clear that that translates to an evidentiary hearing. The magistrate in this case did not conduct an evidentiary hearing. She did conduct a hearing. There are 2 entries and a statement on the record clarifying that the hearing will be limited to arguments on legal theory and that facts will not be, factual evidence will not be heard. It's impossible to argue the legal theories without at least touching on the facts. But although the magistrate said that didn't address the pleadings in the common pleas case, and focused totally on the arbitration process under 2711. Nonetheless suggested that she was able to get a flavor for the facts by reading the pleadings in the case, which would suggest that she's referring to the summary judgment pleadings, although she doesn't state that. The turning point of the magistrate's decision, which was adopted by the trial court, was that the court couldn't consider anything because any objection to the appraisal process or price determination was untimely under 2711, and not addressing a two-step inquiry, not considering that the appraisal process was a different dispute. So the trial court could have said, that is a different dispute. The appraisal, price determination, payment is a different dispute, and sent it back to arbitration, which is exactly what appellees requested at the end of the discovery process and briefing.
I'm going to just pause you, because you're at 4 minutes and 40 seconds, and you did not indicate if you wanted to reserve time.
I apologize, Your Honor. I would like to reserve 3 minutes.
Okay,
So-
so you're back on the clock.
All right, thank you, Your Honor. So, we spoke about the evidentiary hearing. The other issue, although appellees seem to suggest the motion to vacate was broader than it was limited to a very discrete issue. And that issue is whether the arbitration was commenced within 30 days, which is jurisdictional. It was not. That is not a disputed fact. The arbitration was not commenced within 30 days. The case law states that that is jurisdictional. It can be raised at any point. The case law is before the court, and the decision on that is easy. Does the case law determine that the parameters of the arbitration set by the CCA require that they be followed exactly? And if not, whether the arbitrator had jurisdiction. Jurisdiction is not waivable, and that issue is fairly discrete, as is the evidentiary hearing issue. So the focus then is on whether you can confirm something in a 2311 confirmation proceeding that was never decided by the arbitrator, and for parties that were not part of the arbitration, and exactly what that complaint means. And what we suggest to the court it means is that the appellees invoke the jurisdiction of the trial court, that dispute was never resolved, and that this case should be remanded to the trial court so that issue can be resolved. And I'll reserve.
3 minutes and 4 seconds.
Thank you, Your Honor.
And counsel, you'll have 15 minutes.
Thank you, Your Honor. It's a pleasure to be in your new courtroom, and please the court. My name is Ron Cobb, and along with Jessica Lopez, we represent the appellees, Cindy Slezak, who is here, her brother Fred Slezak, and RJS Corporation. I will, because there are so many Slezaks, try to refer to our clients as my or our clients, and we'll refer to Mr. Arnold Slezak as Arnold Slezak. 3 years ago, last month, we arbitrated this case for 3 days here in Akron. And we arbitrated because the parties had agreed that they would put their dispute before an arbitrator rather than litigate, and yet 3 years later, here we are in a courtroom continuing to litigate. My clients absolutely deny that anything was done incorrectly in the share valuation process. In fact, 3 very highly competent appraisers or accountants engaged in that process, which was the agreement of the parties in the beginning. And as a result of that process, Mr. Arnold Slezak was awarded millions of dollars. If my clients have to, they can respond to any one of these incorrect allegations. But as I mentioned, Mr. Arnold Slezak chose long ago not to litigate issues like these. Instead, he chose, along with his siblings, to arbitrate them when he entered the close corporation agreement, as Mr. Kehoe called it, the CCA. And following the arbitration which was held, the parties were ordered to go through an evaluation process which would arrive at a price. And Mr. Slezak was ordered to sell his shares to the company at that price. And that's on the last page of the arbitrator's award, which is part of the record. This was not a two-step process. This was a single award with a single remedy, and the arbitrator ordered how that remedy would be effectuated. Now, Mr. Kehoe mentioned a few moments ago that this evaluation process or this remedy was not requested. I would refer your honors to record 1 at page 43, which is the last page of our arbitration demand, where we specifically required exactly the remedy that the arbitrator in fact ordered. And she did that. Now, why would the arbitrator have ordered a remedy like that? She could simply have arrived at a number, $1 million, $2 million, $4 million. She didn't do that. And she could have also said parties go back and do what the contract requires. The problem is she couldn't really do that because the contract terms, the time limits, had already expired. Recall that Arnold Slezak was terminated on October 23, 2015, and the CCA Section 8 states that that date would be the triggering event, or the triggering date. And all of the dates that followed, 30 days, 45 days, et cetera, for this valuation process, were to be completed within 6 months, according to Section 9 of that CCA. Well, the arbitrator's award came out on May 24, 2016. Well, a lot of that 6 months was gone. So she had to figure out, what am I going to do? She could have done any variety of things, including simply selecting a price. She didn't do that. She said, okay, what you're going to do is to go through the valuation process because that's what you sort of wanted to do anyway. But I am going to, on my own, select a new triggering event date. And that date is going to be the date of my order, May 24, 2016. And then you can look at those dates, those time periods in the contract, 30 days, 45 days, et cetera, and go from there. And whatever that price is, whatever that price that is determined by whether it's 1, 2, or as it turned out to be, 3 independent valuators or appraisers, that's the price that you, Mr. Slezak, will receive in order to turn in your shares. Now,
but necessarily, don't you have to look at that process in some way? You started your argument by saying it was done the proper way.
So, we believe, Your Honor, Judge Carr, that if that process, if that's what they wanted to do, if they thought in the beginning that going through that process would be improper, or if what she had determined was improper, she should have just said $4 million. She should have done something else. They were required to move to vacate at least that portion of her award within 90 days. And I'm sorry.
No, I'm interrupting you. I apologize, but I'm thinking of a situation where the arbitrator says this is the process, okay? And they all agree that that's the process, but then when they actually start doing it, there's a different process that's used. How do you correct that?
Well, you corrected by the beginning saying that we can't go through that process. We disagree with going through that process, and we think that the court should overturn that. Or they could go back and make a demand to arbitrate. They didn't do that. What they did was, on August 1, 2016, which was well within the first 90 days following the award, the Boger-Markey firm, which was the firm retained by RJS Corporations as per this contract, per this award, came out with its valuation. And Mr. Arnold Slezak didn't like what that determination was. He thought it was too low. So at that point, he still had 24 days. He had until August 24, 2016 to be within his 60 days. He didn't do that. Instead, he elected to go through the arbitration, the process of using these 3 independent folks. That's what he elected to do. We believe that by not filing his motion to vacate, modify, or correct, that he waived any objection that he might have had. And by the way, at the end of that process, which was on November 9, 2016, the final the final appraiser came forward, Mr. Bell, with his appraisal. Arnold didn't like that either. And what Mr. Arnold Slezak did was to write, and that is in the record also. He wrote to the appraiser and he said, I disagree with this and I disagree with that. We believe that he still had the opportunity to, that this court could have found or could find that perhaps the 90 days began at that point. I don't know, but he never tried. He never filed a motion to vacate or modify, even though he knew that he had problems with the first report and the third report. He sat back and did nothing. And in fact, what he did was to accept checks that were received to him pursuant to the arbitrator's award. Month after month after month, he received these checks. Now, we learned finally that he wasn't cashing them, which is why we went to the court and asked that the award be confirmed, and went forward from there. Now, Mr. Kehoe says that all of this is somehow unfair to Mr. Slezak, and Judge Carter, your point also, while we don't think that this is fair, here's the thing. Not everything that happens in the law is necessarily fair. I've been before, not necessarily your honors, but many of the judges up on the wall here, occasionally, and I've raised an argument. I recall Judge Dickinson saying, that's a very good argument, Mr. Cott, but you didn't raise that below, and so you've waived it. There are statutes of limitations. There are statutes of repose. There is estoppel. There's waiver. There are all kinds of things that happen that for policy reasons the courts accept because that's what policy requires. And in this case, there has to be an end to this dispute. And the end came when two things happened. And it was the same thing together, that the arbitrator said, here's the award, get this price, and once that price is obtained, that's the price. I'm not going to state it as $2 million or $4 million. It turned out to be $4-point-something million that Mr. Slezak was to receive, and that needed to be confirmed. Now, the Arbitration Act is very, very clear. RC Section 271109 states emphatically that if an application to confirm an award is filed, and I quote, the court shall grant such order and enter judgment thereon. And there's only one exception. There's only one exception, and it's been accepted, of course, by this court and the Ohio Supreme Court, and that is if there is a motion to vacate or modify or correct, and that motion is in some fashion granted, then of course that confirmation would not be granted or would not be granted in full.
What is your position, Mr. Kopp, on the necessity of a hearing on a confirmation award?
Your Honor, I this morning, as a matter of fact, read every case that is referred to. There is not one case in the state of Ohio, including the 5 cases that they have stated, set forth in their brief, that requires an evidentiary hearing. Not one. There are cases that say if you have a motion to vacate because, for example, there's an allegation of fraud, that in that hearing on a motion to vacate, there of course would need to be evidence. But not anywhere does any court say that there must be an evidentiary hearing. In fact, some courts, including the 8th District, say that no hearing at all, evidentiary or otherwise, is required. So let me see if I can drive home one of these last points by providing a hypothetical. If, as I suggested, the arbitrator had ruled that the termination was correct and that Mr. Slezak, Mr. Arnold Slezak, is to receive a certain amount of money, let's call it $4 million. Let me correct that, $1 million. $1 million. And everybody goes on about their way, the shares are exchanged and so on. Well, for a variety of reasons, that would be an incorrect finding. Everybody would know that those shares were worth more than $1 million. Well, in that case, however, if Mr. Slezak didn't do anything about that finding within 90 days, he'd have to accept $1 million. It's the same thing here. She set a price. It was just a price that was to be determined by 3 appraisers. And whatever that price was, set by those 3 professional appraisers, that would be the price. This is arbitration. This was to be arbitration, not litigation. And just a couple of final points before I sit down. Our clients have waived nothing by including other claims in their complaint. The fact of the matter is that our clients have very, I hope, careful lawyers who try very hard not to leave any stone unturned. And there is nothing wrong, at least in my experience, with filing a pleading or a complaint that has alternative theories. The fact of the matter is we didn't believe that the court had authority to provide any ruling on a declaratory judgment motion, but we knew because of correspondence that they disagreed with our position, and we wanted to put that before the court as an alternative if for some reason the court determined that they did not believe that they needed to confirm the award. So belt and suspenders, and I apologize, I'm only wearing a belt today, but when I'm in court I try to use suspenders also, and that's what we were doing. And finally, we're a little perplexed that Mr. Slezak's team, as they continue to argue about this 30-day provision. I mean, the fact of the situation, the fact is that we all agreed, everybody agreed to arbitration. The parties and the arbitrator could not get things done within 30 days, and they all agreed to extend that for an additional, as it turned out, 24 days, and the arbitration proceeded on March 1. Everybody agreed to it. Everybody agreed to it in writing. I admit that I'm the one that wrote the email confirming that we had reached that agreement with the arbitrator. There was not a peep in response to my email, as the record demonstrates. There was not a peep at the arbitration hearing, as the record demonstrates. Not a peep in the later briefing. This didn't come up until this got to court. And so, as so many things can happen, a contract provision can be waived or modified by agreement of the parties, or certainly by waiver, and that occurred here. And so, Your Honors, we would simply ask that, based upon these arguments and the arguments and case law and the law set out in our briefs, that the decision of the trial court be affirmed. Thank you very much for hearing us.
Thank you for your argument, and counsel, you'll have 3 minutes and 4 seconds for your rebuttal.
Thank you, Your Honor. Judge Carr, I think you asked the key question, and I'm not sure I heard an answer. The inquiry is the valuation process and share price determination and payment part of the employment arbitration? The answer is no, it was not. We do not dispute that the arbitration order is subject to 2711. We do not dispute that that order compelled a share repurchase under the terms of the CCA. What we dispute is that that process must have some form of oversight, whether it's in the common pleas court where appellees invoke the jurisdiction of the court, or whether it's another arbitration with the same arbitrator or another arbitrator. We didn't learn about the irregularities in the appraisal process until discovery was undertaken. So the entire argument now in support of the trial court from appellees hinges on timeliness. And I want to, there's another position under the CCA that I don't want to overlook. It's in the briefing. But Section 9 of the CCA states very clearly that the arbitration award is not effective until it is confirmed. The language is, it shall be confirmed. In contrast to the statute, which indicates that an award holder may ask for confirmation within 12 months under 271109, but does not have to. So under the CCA, that award, whatever it means, is not effective until it's confirmed. Ergo, there would be no obligation to do anything until that award is confirmed. And what's the distinction? It's important. An arbitration award holder can obtain the enforcement provisions of a judgment, meaning attachment, garnishment, etc., if you get the arbitration award confirmed. It then has the force and effect of a judgment. If you don't get it confirmed within 12 months, then you have an award without the effect of a judgment that can be enforced. This CCA requires that that process take place. But more importantly, the main inquiry is whether or not the appraisal process, share price determination, and payment must undergo review. So with that, Your Honors, appellant requests that the matter be remanded to the trial court for either adjudication of the complaint and the counterclaim, or stay those proceedings and remand so that the subsequent process can undergo review by an arbitrator. Thank you very much.
All right, the court wants to thank both of you for your arguments today. The court will take the matter under advisement, issue a decision in due course, or will of course receive copies of the decision on the day it's released from the clerk of courts, and the decisions are also posted on the Supreme Court of Ohio's website. So